SJC-12381, Commonwealth versus Timothy Kostka.
Okay, Attorney Curran, when you're ready.
Good morning. May it please the Court, Dana Curran for Timothy Kostka. The main issue in this case involves the evidence of lottery tickets. It was the Commonwealth's position that Mr. Kostka was observed cashing lottery tickets that were consistent in numerical sequence with losing tickets that were found in the victim's house. During discovery, the Commonwealth provided two sets of documents, one produced by the vendor and one produced by the lottery based on information from the vendor. The key piece of information on these documents was a number called the VIRN number, which essentially would show purported to show the ticket, the book, the game, and if the tickets were in sequence, then that would certainly be problematic for Mr. Kostka. The problem is that these documents actually didn't either didn't show or were inconclusive as to a lot of the information. They seemed to show the game, but they didn't show the book number and the ticket number, and the two sets of documents were actually consistent with or inconsistent with each other. Now, what happened was about the fourth day of trial, the Commonwealth produced documents directly from the lottery. Sometime between 2012 and 2015, the lottery gained the ability to produce its own printouts and documents without going to the vendor. And these documents, the VIRN number, was a much closer match and purported to show the game number, the book number, and the ticket number.
Can I ask, Mr.
Yes.
Curran? So I tried making sense of this, and I couldn't. So when I look at the documents you submit, I can't see if there's a pattern or not. The Commonwealth just says there's a pattern in the earlier documents. Can you, when we do a really close comparison of what was produced in discovery versus what comes out later, is there a pattern in the stuff produced in discovery if you look closely enough? Or is it just a jumble the way you describe it?
I couldn't find a pattern, and it's dense. I can't stand here. I could stand here until tomorrow and try to explain what the numbers mean, but I really don't know.
But when we go closely, and I'll be honest, I tried, but I didn't have enough time. But because I'm going to ask the Commonwealth this, because they just sort of say, oh, these documents are exactly the same, meaning I take it that there's a pattern in this thing if you look closely enough. And you say, no, it's just a bunch of jumble. Is it somewhere in between that if you look closely, you can see the pattern, but it's sort of obfuscated? But tell me what, because we are going to look closely, or at least our law clerks are going to dig into those numbers very carefully.
I mean, I think my position is that there is no discernible pattern. And that
So in discovery, they produce documents that are just numbers all over the place. And then 4 days into trial, they produce documents that clearly show the pattern, meaning that the victim, the lottery tickets in the victim's house are clearly in sequence with what's the defendant is cashing. Is that right?
Right. And the argument that the defense made throughout, once these new materials came in, was that, look, we were going to take these documents and show either that the tickets were not in sequence, or that you just can't tell. And there was a voir dire on this, and the Commonwealth essentially said, well, it's the same information, just in different form. And that's how it was left. The judge said, well, if it's the same information, I'm going to admit the new stuff and exclude the old stuff, except that if you want to use it, you, the defense, if you want to use it for impeachment purposes, you can do that.
But when we go through the old stuff, meaning the stuff that was produced in discovery, closely, we're not going to be able to highlight sort of parts of those numbers and show there is a sequence that's obvious.
I don't think we can do that. And you know, the explanation came out on cross-examination from the guy from the lottery. Nobody from the vendor came. But the guy from the lottery, what he said this several times, but probably the best quote is in volume 8, page 171, quote, "I believe this number was, from what was explained to me, is encrypted by the computer somehow, and that's how they figure it out." The problem is that if these earlier numbers, and this is the first time anybody ever said anything about encryption, but if these numbers were indeed encrypted, nobody provided anybody, particularly the defense, with a key. You know, this is how you figure it out. It's like, here's the numbers. And then the judge essentially said, well, if they're saying it's the same information, you've already gotten discovery, and you know everything's the same except the VIRN number, and so it's no big deal. The problem is it is a big deal because the VIRN number is what actually tells you how to figure this out. And the VIRN number is different. You know, the new and improved version that
In your view, they sort of sent you, you know, in World War II, we had people deciphering the code. So you have something you put in that will allow you to convert these numbers into something comprehensible. But they didn't give you the ability to do that.
No, they did not. And, you know, that's a problem because it was a surprise. It was, and you know, I think that we challenged this in the motion for new trial, and the judge actually said.
Say we agree with you. Is this still an open and shut case against your client? Your client's blood's there. His fingerprints are there. Even accepting their own witness that he was there once, right? How many years ago was that when he bought the boat?
I think it was 2006 he bought the boat. In 2007 he bought some fishing equipment.
And then this murder takes place when?
This would be, I think, 2012.
We've got, at best, your client was in the house 6 years ago, but they discover his blood in the house, and they discover his fingerprints. Where is his blood found, and where are his fingerprints?
I don't think his blood is found. There is what is described as a bloody or dirty fingerprint, and it was somewhat distorted, but it was matched to the defendant. And the defense produced an expert that said, you know, I followed the same protocols, and I wouldn't have called this a match. There were a couple of fingerprints found on other items.
So the defendant's DNA profile contributed to the mixture found on the swabs of the victim's fingernails. The portion of the defendant's DNA profile was 1 in 40,000 Caucasians. Is the defendant Caucasian?
Yes, he is.
So 1 in 40,000, right, okay.
I mean, I was here a few weeks ago, and we talked about DNA, and we were talking about 1 in something quadrillion. And yes, that is definitely a DNA match. I would say there was room to, for this, in this case, to argue that it wasn't a match. It was consistent, but it wasn't necessarily a match. The jury in this case was out for over the course of 3 days deliberating. The victim, before she lost consciousness, her son asked who did this, and she didn't say it was Timmy or Tim Kostka or anybody she knew. She gave a description, and the description that was called out was a middle-aged white male with a white shirt. And so I think there was reason for the jury. I mean, let me put it this way. It was a triable case. I'm not saying that the evidence wasn't legally insufficient, but I am saying that it is a triable case. And if you take out the lottery tickets, if the lottery tickets don't match, this store was 2 blocks over and 1 block up from where the crime took place. It would have been very difficult for the defendant to get there in the time period. But it was also 1 block up from the South Boston Yacht Club where he kept his boat. So again, if he's there cashing lottery tickets, that's significant if the lottery tickets are in sequence with losing tickets found in the victim's house, but it is not so much if he's just working on his boat and goes up there for a Snickers bar and a couple of lottery tickets or cashes something in. And he was there a couple of times that morning cashing lottery tickets. So I think the key in this case was it was definitely the lottery tickets. And, you know, that decision to admit the new evidence and essentially exclude the stuff that was provided in discovery, you know, was significant in a number of ways. And one of the ways is that when the testimony came out about this being encrypted, about the earlier ones being encrypted, the prosecutor got up and said something like that the jurors should ask yourselves whether truly the numbers do not match or whether there was some gamesmanship in the numbers playing by the defense. I mean, I think that was improper. It was, you know, not only was the defense ambushed at trial, but then that was used against the defense in a variety of ways that were unanticipated and that were very harmful to the defense. Unless there are any further questions, I will leave the remaining points of the brief.
Okay,
Thank you.
thank you. Attorney McLean.
Good morning. May it please the court. Ian McLean on behalf of the Commonwealth, and along with me at council table is trial prosecutor Ursula Knight. I'd like to begin by recognizing several members of the victim's family, Barbara Coyne, that are in the audience with us here today. Your Honors, this court should affirm the convictions here for home invasion and the brutal murder of Barbara Coyne that occurred during the daylight hours of Marathon Monday in 2012. As Justice Kafka pointed out during my brother's argument, this is basically an open and shut case against the defendant.
I asked if it was an open and shut case, but before you get to the open and shut argument, I read your brief, and I was first, and I said, oh, what you gave them and what happens at trial must be the same or must be similar. And then I started going through the documents, and I can't make sense of them. So tell me how the defense counsel, who's presented with that gobbledygook of numbers, has the same documents that you produced 4 days into trial that makes this an open and shut case.
Sure, Your Honor. With your permission, I'll walk you through
Yeah.
one of the particular tickets
Go ahead.
explaining. I mean, it would be best if I could have a chalkboard to do this, but I'll try to do it verbally as best as I can. You start with Exhibit 194 from trial. That was the 2012 Lottery Commission document referred to as a transaction report. You can find it at Defense Appendix 73. That's an Excel spreadsheet. And the reason they used Excel spreadsheets in 2012 is because those things are filterable or sortable. So based on what they were looking for, they could move the cells around. So what they produced was the material the way they used it in an Excel spreadsheet. So that's Defense Exhibit 73. And you take that page and compare it against Defense Appendix page 163.
So give me let's take a ticket. So give me a ticket.
I'm going to walk you through one ticket from start to finish, Your Honor, if that's okay.
Go ahead.
So take Appendix page 73, look at the transaction that occurred at 11:52:09. That's Game 51, Book 24403, Ticket 093 for $4. And then a whole VERN number, the void if removed number. If you compare that data against Defense Appendix page 163, the same time transaction, 11:52:09, You see the same game number, 51, the same book number, 24403, the same ticket number, 093, the same transaction redeemed, $4. Compare the VIRN numbers, and they match for the first about 10 digits. 51234993848. That's the portion that they match to. Then there's a discrepancy. The JFI report drops 2 digits, and then the JFI report continues on. Now, the reason the discrepancy is there was explained by Kevin Carroll during the voir dire before these documents were admitted at trial. And what Kevin Carroll explained was, in 2012, the Excel spreadsheet format, the cell...
Okay, but I'm looking at some of this, but, so at 1152, those numbers, now, are those the same exact numbers that appear in the numbers that you give later, or are they different numbers?
They're the same, Your Honor.
And so, okay, so I see this number 512349938, right?
Yes.
And is there a same number in succession from the victim that you can compare that to and say, oh, that's that number, and then the victim's number is just one more? Where do I find that?
No, Your Honor. The void if removed number, the VERN number, is essentially not the important piece of data. The important piece of data is the other components that you see on Defense Appendix 73 and 163, the game book ticket number. So there, we're talking about ticket number 93.
Simplify this for me. When I'm a lawyer and I have the victim's lottery numbers back at the house, and I have these numbers at the lottery. They pick these up when the defendant cashes them. The defense counsel can say, oh, I've got that number that succeeds that number. They can do that?
Yes, Your Honor.
The same way you do it at trial?
Yes, Your Honor. So each lottery ticket has a unique number assigned to it that's on the back of the ticket itself. That number is comprised of the game number, the book number, the ticket number.
Right.
So here in 2012, at Defense Appendix 73, it shows game 51, book 24403, ticket 93. Then Exhibit 124M and N at trial show the tickets numbers on either side of that ticket, ticket 92 and ticket 94. So the redeemed ticket was 93. The 2 tickets that were discovered at the victim's residence, the losing tickets, were on either side of that from the roll, 92 and 94.
And they had 10 numbers that matched up to that, or just the numbers 92 and 93 in a long series of numbers?
So
are
that whole series of numbers matches up. They call it the serial number, Your Honor. It's the number on the back of the ticket, and that number is comprised of a 2-digit game number, a 6-digit book number, and then the individual ticket within that book of tickets. So here, this transaction, 115209, for ultimately ticket number 93 in that roll, is the same as the ticket that was between 2 of the losing tickets that were found at the victim's residence that have the same game number, book number, and then our ticket 92 and 94 on either side. So that's how it works. So all the data that the defendant was complaining about in the information that was received from the State Lottery Commission pursuant to a trial subpoena and was introduced at trial that you see at Defense Appendix 163 was contained in the material that he was given in 2012, the 2012 Lottery Transaction Report, Defense Exhibit 7, or Appendix page 73. So I've used that ticket as an example just because that's the clearest ticket where that redeemed ticket, both tickets on either side of that ticket were found in the victim's residence. So, and I would point out that the trial judge actually went through this process during the voir dire with Kevin Carroll, and that's where that testimony was elicited explaining why they used the 2012 Excel spreadsheet as opposed to the JFI report that they used in 2015 that was produced pursuant to the trial subpoena. And that explanation was the Excel spreadsheet is filterable or sortable, so it's better for them as investigators to be able to control and move the data around. So here, all of the information was produced to the defendant in advance of trial. What was received pursuant to the trial subpoena was merely the same data in a different format that was then introduced at trial. The defendant had an opportunity to extensively cross-examine Kevin Carroll from the Lottery Commission on this subject. He was actually permitted to introduce the documents that he had received in discovery, the 2012 documents, despite not laying a foundation for the admissibility of any of those documents as part of his cross-examination.
So it was so clear, why did you have to put in a new document that you didn't produce in discovery?
Well, we simply obtained it via trial subpoena, Your Honor, as happens routinely in cases.
And how much time in advance did you give them that document?
I'm sorry, Your Honor?
How much time in advance at trial did you give them the new document?
As soon as we received it, Your Honor. I mean, as you well know, a trial subpoena, we can only subpoena the documents for the first day of trial. So as
Right,
soon as
no,
we...
I get it. So the defense counsel had it how long before it's actually introduced?
I would have to check the records, Your Honor, but it came... (9/28) is the day that it came, that it was received in the docket. According to the docket entries, that's the day that the material was received at the court.
And it goes into evidence in trial what day?
The 8th day of trial, Your Honor.
So there's 8 days.
Yes. So here, the defendant failed to meet his burden for establishing a discovery violation. So if you evaluate it as a question that occurred during trial that the trial judge evaluated then, it would be reviewed for an abuse of discretion. Same if we look at it as a denial of the motion for a new trial, it would be reviewed for an abuse of discretion. The trial judge here simply didn't abuse their discretion. The defendant failed to establish his burden that he has to meet for a discovery violation of showing, one, there was a late disclosure, and two, that there was prejudice from it. So here, he had all of the same material produced in discovery, and he had the ability to extensively cross-examine Kevin Carroll about the JFI report itself and any discrepancies that he perceived between the two reports. He also had the opportunity during discovery or trial prep to try to interview Mr. Carroll if he chose to. So he had an opportunity to prepare himself for this situation and failed to establish any prejudice therefrom. I'd also then point back, Your Honor, to the overwhelming nature of the case against the defendant here.
Yeah,
The
can
fact
you
that his-
summarize? We have the fingerprint, describe the fingerprint evidence, the other DNA evidence, and we also have evidence that he told one of his friends that if he got caught burglarizing, he was going to cut someone's throat, right?
Yes, Your Honor. Yes, Your Honor. He informed one of his friends that he was financing his heroin addiction by committing armed home invasions in Southie, where this crime occurred. And when his friend prompted him, what would he do if someone was home, he showed him a knife and indicated he would slit their throat, which is exactly what he did to Barbara Coyne here. We know that he was there in the house because we have his fingerprints in 3 separate locations. 2 fingerprints in Barbara Coyne's bedroom on her jewelry boxes, just feet from where she was found bleeding to death on the ground. 1 fingerprint out in the living room on an envelope in blood. We also have his DNA, 1 in 44,000 as a contributor, underneath her fingernails. When you take those factors together, I would also add in the fact that just an hour or so after the murder, he then contributed $90 to one of his regular drug associates to purchase $100 worth of drugs.
Can I ask about the timing? From what I understand, the brother or one of the sons of the victim goes downstairs, but he doesn't see her. Is that right? Because there's a timing issue about when he sees the door open and then he goes in, right? But he's moved about the house earlier. Does that rule out that this occurred earlier or not? He doesn't see his mother alive earlier, right?
Yes, he did see his mother alive earlier that morning, Your Honor. Had a cup of coffee with her.
At what time is that?
I'm sorry, Your Honor, I don't recall off the top of my head what time that was. I'll submit a...
But the defense counsel at one point says he has to get to that store very quickly after there isn't enough time to get to the store. I take it that assumes that the brother had seen her when he first goes down the stairs. I'm not sure I fully followed that timing argument. When does the brother sees the door open, the son sees the door open, and he goes into the house, right?
He's inside the house, Your Honor. So he sees an interior door. The door to Barbara Coyne's residence is right before you would take the exterior door to exit the residence. So he's on his way out to go down to the marina to work on his boat. He notices the door to his mother's apartment is open, and he enters
doesn't
that.
see his mother. He sees his mother alive. How much earlier in the morning?
The last time that he saw her, Your Honor, I believe was about 8 minutes before that.
So that we know the crime takes place in that 8-minute period?
Yes, Your Honor.
So that 8-minute period is from when to when? I'm just trying to understand that.
Your Honor, I don't remember the exact time of that 8-minute window of time, but I'll submit the letter on that.
Then the defense counsel suggests that there's not enough time to get to that store. Why is that wrong?
It's just a couple of blocks away, Your Honor. His argument is that the defendant was not captured on video cameras that would have potentially captured him traveling that route to the store. That's what his argument boils down to, Your Honor. But I would point you back to the fact that his fingerprints were there, not just in a random place where it might have been placed there 6 years before and somehow magically not been removed. They were on the 2 jewelry boxes in the bedroom where the victim was found. And another fingerprint of his was found in blood in the apartment on an envelope, a disposable item that presumably wouldn't have been there for very long. And his DNA, 1 in 44,000, was found underneath her fingernails. Then, about an hour, hour and a half after the murder, he all of a sudden has $90 in cash to contribute to a heroin purchase when he had just been seen on video redeeming $100 worth of scratch tickets. And then the lottery records established that some of those scratch tickets that he cashed in were attached within the roll to losing tickets found in the victim's apartment. Combine that with the fact that he had no justification, even in the light most favorable to him, he had no justification to have been in that residence in the past 6 years. He was there to commit an armed home invasion, as he told his friend he was doing, to finance his heroin addiction. So, Your Honor, the defendant seems to have abandoned the argument of the JFI report themselves being improperly admitted as a business record. I'll just briefly address where the foundational requirements could be found. It was found in an extensive voir dire of Kevin Carroll, the Lottery Commission security man, who testified in Volume 8 of the transcript, and he established the predicates for the business record foundation, testifying that the underlying data was recorded in the ordinary course of business for their own internal use, for fraud investigations, security investigations, and to deal with any customer complaints. That satisfies the first and second prong of the requirement. He also testified that it's collected in real time down to the second, the moment that one of these tickets is redeemed at a lottery terminal. So that satisfies the third requirement, that the data was recorded before the beginning of the criminal proceeding. And he also testified it was conducted in the regular course of their business, so they could retain this information when they needed it for security investigations. So the business foundation predicate was established here. The documents were admissible. The defendant failed to establish a discovery violation, as we previously discussed. So then turning to his next claims in the case, they pertain to the closing arguments. There were 2 essential claims that were made. The first was that the prosecutor relied on and argued facts that she should not have, which was an interesting claim because those facts were in fact in evidence. What she was referring to was exact testimony from Kevin Carroll. The complaint was that it was improper for her to argue the VERN did not match because some of the data was encrypted. That was a reference exactly to Kevin Carroll's testimony, and I point you to transcript volume 8, pages 171 to 172, and page 195. I'd also point out that testimony was elicited on cross-examination. There was no objection, there was no motion to strike, so it was within evidence, so it was proper for her to refer to it. It was also a fair response to the defendant's closing argument, where he challenged the VERN records. So she was simply pointing out a reason that the witness testified to why the VERNs were not perfectly matched, because some of the data was excluded as it was encrypted, because the VERN is a particularly valuable piece of information. It coordinates to the barcode on the ticket. So if you had a VERN, you could type it into a lottery terminal and redeem a winning ticket without even having that ticket in your hand. So further, if the court was to find that that was improper, there was no prejudice here. The jury was fully instructed by the judge both in advance of closings and then it was reiterated prior or post closings that the lawyers were merely suggesting what the evidence was and what it means and what inferences they think should be drawn from it, while it was their decision to actually decide what the evidence was. So any possible prejudice there would have been was remedied by the instructions from the judge on that point. The defendant's other point about the single reference in closing argument using the word gamesmanship to describe the cross-examination tactic that defense counsel used on the State Lottery Commission's security expert, Kevin Carroll. When you place that single word in context, it becomes very clear that what the prosecutor was doing was asking the jury to compare the questions being asked by the defense attorney against the testimony that was given in response to that. That's directing the jury to the evidence of the case. That's proper argument. If the simple use of the word gamesmanship is what we're going to evaluate, I point you to the Andre case, which was a stronger version of the same sort of argument. I'd also point you to the Felder case, again, a stronger version of the same sort of argument where it was proper to suggest that defense counsel was raising smoke screens. I'd also point you to Raposa, where it was fair to argue the defense counsel could spin gold from straw. So here we have much less than that. And it is clear that it is just a comment on a tactic the defense counsel used. It's completely unlike Gentile, where what the prosecutor did was refer to the defense attorney as despicable. That's a personal attack on defense counsel, and that's not acceptable. That's improper. Here, this is nothing like referring to the defense counsel as being despicable. It's referring to a tactic the defense counsel employed during the cross-examination of a particular witness. Entirely appropriate. If the court was to think there was error in that, I would again say there's no prejudice because juries are presumed to be able to discount hyperbole in closing arguments. And also there was a specific instruction from the judge to the jury that they should not be swayed by emotion or zealousness of the lawyers and should instead focus on the evidence, which is what the prosecutor was attempting to do here. If there are no further questions,
Okay,
thank you.
thank you.